Consideration transforms a promise into an enforceable contract. Without consideration, a promise is just a promise, as the plaintiff learned in Springstead v. Nees. Nees died intestate, leaving his 5 surviving children his sole heirs at law. The children included Sophia and George Nees and Anna Springstead. When Nees died, he owned real property known as the Sackett Street property and held property known as the Atlantic Avenue property in trust for Sophia and George. Shortly after Nees's death, the children and an attorney gathered at Nees's house. The attorney found the deed to the Atlantic Avenue property in Nees's strongbox and gave it to Sophia, saying that it was hers. Some of the children expressed surprise and dismay that their father had held the property in trust for only 2 of them because they thought he'd owned it outright. Sophia promised that she and George would give the others their shares in the Sackett Street property if the others left Sophia and George alone about the Atlantic Avenue property. George agreed with Sophia. Later, the Sackett Street property was sold. Anna Springstead and the 2 other children sued Sophia and George to recover Sophia and George's shares of the proceeds from that sale, as Sophia had promised. The trial court dismissed the complaint and entered judgment for Sophia and George. Springstead appealed to the New York Supreme Court Appellate Division.